Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. Would ask our guests here in-house to make that last courtesy check that cell phones have been muted as we prepare to begin. It is always appreciated. And, of course, our internet viewers are always reminded that you can send questions or comments at any time simply emailing us at speaker@heritage.org. Opening our discussion today is Paul Larkin. Mr. Larkin serves as Senior Legal Research Fellow in the Edwin Meese Center for Legal and Judicial Studies here at Heritage. Please join in welcoming Paul Larkin. Paul?
Thank you all very much for coming and sharing part of your day to listen to this debate. 142 years is a short period of time in the life of a mountain range, such as the Rockies, or an idea, such as democracy. But it is an eternity in the lifespan of a Supreme Court decision. One such decision, known as the Slaughterhouse Cases, was decided that long ago. The Slaughterhouse Cases involved a challenge to a monopoly created by the Louisiana legislature. Ostensibly to improve health conditions in the city of New Orleans, Louisiana decided to have only one abattoir within the city limits. Other slaughterhouses filed suit, arguing that the law, by creating a monopoly, violated the Privileges or Immunities Clause of the 14th Amendment. Like most provisions in the Constitution, the Privileges or Immunities Clause has a Delphic simplicity. It provides, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." Those terms might seem straightforward to anyone whose mind has not been spoiled by legal education, but no text is that simple to lawyers. There are at least 5 different meanings of the Privileges or Immunities Clause. For example, it could mean any one of the following. Privileges or immunities could be the guarantees set forth in the Bill of Rights. They could be a set of unenumerated rights guaranteed to, quote, citizens of the United States. It could be a set of unenumerated rights guaranteed to everyone by virtue of natural law. It could contain a requirement that each state grant to citizens of the United States whatever rights the state grants to its own citizens. Or it could be a subset of those rights, drawing a distinction between political rights, such as the right to vote, which would not have to be granted, and civil rights, such as the right to bring a lawsuit, which would. In the Slaughterhouse case, the Supreme Court decided that the Privilege or Immunities Clause has the second meaning that I mentioned above. It is a set of unenumerated rights guaranteed to citizens of the United States. The Legal Academy has excoriated the Slaughterhouse Cases. Leonard Levy called it, quote, "one of the most tragically wrong opinions ever given by the Supreme Court." Charles Black labeled it, quote, "probably the worst holding in its effect on human rights ever uttered by the Supreme Court." And the list goes on from there. Entire forests have been felled in the Academy's efforts to explain why the Slaughterhouse Cases were wrongly decided and what the Privileges or Immunities Clause means. The proper meaning of that clause still has currency today. A majority of the Supreme Court has said that the decision might be wrong, but hasn't decided. By contrast, Justice Clarence Thomas has said he'd be willing to reconsider it, and seems to indicate that he thinks it does have a great deal of currency. Today we will hear 2 distinguished scholars debate that issue. First up is Professor Randy Barnett. He is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where he directs the Georgetown Center for the Constitution and teaches constitutional law and contracts. A graduate of Northwestern University and Harvard Law School, Professor Barnett has published more than 100 articles and 9 books, including Restoring the Lost Constitution and The Structure of Liberty. He frequently appears on news programs on CBS, NBC, PBS, CNN, and Fox News. And I think secretly hope someday to be on The Simpsons. Next up is the Honorable Stephen Markman of the Supreme Court of Michigan. Before going on to the bench, Judge Markman served in both the federal legislative and executive branches. He was chief counsel of the Senate Subcommittee on the Constitution and deputy chief counsel of the Senate Judiciary Committee. He also served in the Department of Justice. He was Assistant Attorney General for the Office of Legal Policy and U.S. Attorney for the Eastern District of Michigan. Justice Markman has authored articles in the Stanford Law Review, the University of Chicago Law Review, the Harvard Journal of Law and Public Policy, and elsewhere. Please give these gentlemen a very warm welcome and give them the opportunity to engage this debate.
Well, thanks, Paul. Thanks for that introduction. I'd never even considered being on The Simpsons. I suppose it's what everybody aspires to, but it just seems beyond any reasonable expectation. I was in a science fiction movie. I played a prosecutor in a science fiction movie called Inalienable, and there was an alien in that picture. And it was a thrill, actually. I never thought I'd do that either. And you can get it on Amazon if you want. At any rate, it actually relates to the beginning of my talk on the Privilege and Immunities Clause. Imagine you're an alien. Imagine you're an alien from another planet, and you land on Earth to read our Constitution. And this alien comes to the part of the Constitution that says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, do you think that would sound pretty important? No state shall make any law which shall abridge the privileges or immunities of citizens of the United States. That would seem to be a pretty big deal. I think this alien would be very surprised to learn that the Supreme Court of the United States has entirely ignored this provision for 140 years, this seemingly very important provision. Now, actually, since you mentioned the slaughterhouse cases, I really didn't know that was going to necessarily come up given our debate topic. Wednesday night, I gave a lecture at the Supreme Court Historical Society at the court, hosted by Justice Thomas, in which it was a lecture all about the slaughterhouse cases and the wonderful stories that are behind that case. But in that lecture, I bracketed the question of what the original meaning of the Privileges or Immunities Clause is on the grounds that it was something I really couldn't get into during this lecture about the case itself. And today, that's what this subject is about, really, what is the Privileges or Immunities Clause about? But the problem with a format like this and handling a question like this is that I can't possibly, in the 15 minutes I'm granted here, present the evidence that's necessary to establish the original public meaning of the Privilege and Immunity Clause. It just cannot be done. So I've been asked to do, and Judge Markman's also been asked to do, something that's really just not possible to do. So I'm going to do the next best thing, and that is I'm going to appeal to authority. I don't usually do it, but I've got no choice, so I'm going to appeal to authority. So consider the following opinion, and I'm going to read you something that's very, very long for a speech, but just consider the following opinion. The Privilege and Immunities Clause, quote, and everything that follows now for a while is going to be a quote, relates to the privileges and immunities of citizens of the United States as such, and as distinguished from all other persons not citizens of the United States. The effect of this clause was to constitute ipso facto the citizens of each one of the original states, citizens of the United States. And the Constitution declares in Article 4 that they are entitled as citizens to all the privileges and immunities of citizens in the several states. They are, by constitutional right, entitled to these privileges and immunities, and may assert this right and these privileges and immunities, and ask for their enforcement whenever they go within the limits of the several states of the Union. The Supreme Court has never undertaken to define either the nature or extent of the privileges and immunities thus guaranteed. But we may gather some intimation of what probably will be the opinion of the judiciary by referring to a case adjudged many years ago in one of the circuit courts of the United States by Justice Bushrod Washington. In the case of Corfield versus Coryell, Justice Washington says, now the person I'm quoting is going to quote Corfield versus Coryell. The next question is whether this act infringes that section of the Constitution which declares that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. That's Article 4, Privileges and Immunities Clause. Justice Washington continues. The inquiry is, what are the privileges and immunities of citizens in the several states? We feel no hesitation in confining these expressions to those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free government, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, all be comprehended under the following general heads: protection by the government, the enjoyment of life and liberty with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole. The right of a citizen of one state to pass through or reside in any other state for purposes of trade, agriculture, professional pursuits, or otherwise, to claim the benefit of the writ of habeas corpus, to institute and maintain actions of any kind in the courts of the state, to take, hold, and dispose of property, either real or personal, and an exemption from higher taxes or impositions that are paid by other citizens of the state, may be mentioned as some of the particular privileges and immunities of citizens which are clearly embraced by the general description of privileges deemed to be fundamental, to which may be added the elective franchise as regulated and established by the laws or constitutions of the state in which it is to be exercised. These and many others which might be mentioned are, strictly speaking, privileges and immunities, and the enjoyment of them by the citizens of each state in every other state was manifestly calculated, to use the expression of the preamble of the corresponding provision of the old Articles of Confederation, the, quote, now quoting from the Articles, the better to secure and perpetuate mutual friendship and intercourse among the people of the different states of the Union. Unquote from Bushrod, Washington. Now the person I'm quoting continues. Such is the character of the privileges and immunities spoken of in the second section of the fourth article of the Constitution. To these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. And I will note the reference here is not to the Bill of Rights. I'll say more about that in a minute. The reference is to the first 8 amendments of the Constitution. The first 8 amendments of the Constitution, such as the freedom of speech and of the press, the right of the people peaceably to assemble and petition the government for redress of grievances, a right appertaining to each and all the people, the right to keep and bear arms, the right to be exempted from the quartering of soldiers in the house without the consent of the owner, the right to be exempt from unreasonable searches and seizures, and from any search or seizure except by virtue of a warrant issued upon a formal oath or affidavit, the right of an accused person to be informed of the nature of the accusation against him, and his right to be tried by an impartial jury of the vicinage, and also the right to be secure against excessive and against bail and against cruel and unusual punishments. Now, sir, here is a mass of privileges, immunities, and rights, some of them secured by the second section of the fourth article of the Constitution, which I have recited, some by the first 8 amendments of the Constitution, and it is a fact well worthy of attention that there is no power given in the Constitution to enforce and carry out any of these guarantees. They are not powers granted by the Constitution to Congress, and of course do not come within the sweeping clause of the Constitution authorizing Congress to pass all laws necessary and proper for carrying out the foregoing granted powers. But they stand simply as a Bill of Rights. All of those stand simply as a Bill of Rights in the Constitution without power on the part of Congress to give them full effect, while at the same time the states are not restrained from violating the principles embraced in them except by their own local constitutions, which may be altered from year to year. The great object of the first section of this amendment is therefore to restrain the power of the states and compel them at all times to respect these great fundamental guarantees. The lengthy explanation I just read was from a speech given on the floor of the Senate on May 23, 1866, by the Senate sponsor of the 14th Amendment, Senator Jacob Howard of Michigan. Although he was born in Vermont, Howard moved to Detroit in 1832, Detroit, the place where Judge Markman and my mom were born, in 1832, and he eventually became the city attorney of Detroit, a member of the Michigan State House of Representatives, a founder of the Republican Party in Michigan, and eventually Michigan Attorney General before becoming United States Senator. In other words, like Judge Markman, Jacob Howard was a good Michigan man. Howard's speech was reproduced in its entirety by newspapers and circulated throughout the nation. Afterwards, the 14th Amendment came to be called the Howard Amendment. According to Howard, the public meaning of privileges or immunities of citizens of the United States included the fundamental rights to which Justice Washington said Privileges and Immunities Clause of Article 4 referred, plus the personal rights guaranteed by the first 8 amendments. All of these he considered to be a Bill of Rights in the Constitution. Now, we are accustomed to thinking of the Bill of Rights as referring to the first 10 amendments, but this usage did not actually take hold until about the time the 14th Amendment was ratified. In the early years of the Republic, they were referred to simply as the amendments. For example, in my extensive research on anti-slavery constitutionalism, I found no example of any abolitionist using the term Bill of Rights. For Jacob Howard, and also for John Bingham on occasion, the privileges and immunities of Article 4 were part of the Bill of Rights of the Constitution. Now, in addition to offering this statement by Senator Howard, I wish to make 3 additional points before yielding the floor to Judge Markman. First, Justice Washington's formulation of the privileges and immunities of citizens was not original to him, by no means. When he referred to, quote, the enjoyment of life and liberty with the right to acquire and possess property of every kind and to pursue and obtain happiness and safety, he was invoking what had become the canonical statement of natural and inalienable rights, which had originally been drafted in 1776 by George Mason for the Virginia Declaration of Rights. Mason's draft read as follows: that all men are born equally free and independent and have certain inherent natural rights of which they cannot, by any compact, deprive or divest their posterity, among which are the enjoyment of life and liberty with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. Literally the wording of Corfield versus Coryell, the exact same words. This language was then included in the constitutions of Virginia, Pennsylvania, Massachusetts, New Hampshire, and Vermont. We know this language was considered judicially enforceable at the time the Constitution was adopted because the Supreme Court of Massachusetts relied upon it in 1783 to hold that slavery was unconstitutional in Massachusetts. They relied on that language to hold it was unconstitutional in Massachusetts. Nor was Senator Howard the only one to quote this passage from Corfield. It was repeatedly cited and read into the congressional record. So what Howard's speech shows is that Mason's canonical formulation of inherent natural rights, of which all men cannot by any compact be deprived or divested, was transmitted through Justice Washington's reading of the Privileges and Immunities Clause of Article 4 to those who wrote and ratified the Privileges or Immunities Clause of the 14th Amendment. These inherent natural rights or immunities were then combined with the additional guarantees or privileges contained in the text of the United States Constitution, together comprising what Howard referred to as, quote, the mass of privileges, immunities, and rights that were protected by the Privileges or Immunities Clause. My second point is, at the same time Congress was drafting and considering the 14th Amendment, it was also passing statutes to protect the privileges or immunities of the freedmen. The Civil Rights Act of 1866 specified these as the rights, quote, to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, sell, lease, hold, and convey real and personal property, unquote. None of these rights are specifically enumerated in the Constitution. In 1866, Congress revised the Freedmen's Bureau Act to specify these rights: the right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, sell, lease, hold, and convey real and personal property, and to have full and equal benefit of all law and proceedings concerning personal liberty, personal security, and the acquisition, enjoyment, and disposition of estate, real and personal, including the constitutional right to bear arms. So you see that in addition to the unenumerated rights of contract and property, the Freedmen's Bureau Act also protected one of the enumerated rights that were in what we now call the Bill of Rights. All these laws were enacted by Congress under the authority granted to it by Section 2 of the 13th Amendment that empowered it to enforce this article by appropriate legislation. And then they were all vetoed by President Andrew Johnson, who claimed that they were beyond the enumerated power of Congress to enact under the 13th Amendment. Some Republicans, congressmen like John Bingham, tended to agree. And all of the Republicans were concerned about the Democrats repealing these statutes after the representatives of the southern states were readmitted to Congress. For these reasons, many Republicans sought a constitutional amendment so that the courts could protect these privileges or immunities even after the Democrats resumed control. And to empower them to pass the civil rights laws, Section 5 of the 14th Amendment was added to give Congress an enumerated power to enforce Section 1. As Senator Howard explained in his speech, quote, Section 1 is a restriction upon the states and does not of itself confer any power on Congress. The power which Congress has under this amendment is derived not from that section, but from the 5th section, which gives it authority to pass laws which are appropriate to the attainment of the great object of the amendment. Okay, my final point concerns how the courts can enforce the Privileges or Immunities Clause in Section 1 as they were expected to do. But I have to go through this quickly. Ever since the post-New Deal courts created the doctrine of preferred freedoms, we are accustomed to thinking of rights as trumps over all legislation. So it matters a great deal which rights are deemed to be fundamental, and you can only protect a favored few, or you're basically going to do away with all law. But that's not how constitutional rights were conceived before the New Deal. Traditionally, the natural and inalienable rights retained by the people may be regulated reasonably. A reasonable regulation was not merely a law that a reasonable person thought was okay. Instead, it is a law that is not irrational or arbitrary. A measure is, and these are somewhat terms of art, an irrational law is one where the means chosen, a measure is irrational if the means adopted poorly fit the supposed end. A measure is arbitrary if the liberties of some are being restricted in ways that the liberties of similarly situated persons are not. Irrational means the means don't really fit the end you say you're doing, so maybe you're not doing it for that end. And arbitrary means you're regulating these people in ways that are different than those people. Maybe the reasons you're regulating these people may not be entirely kosher. Kosher is another legal term. The inquiry into rationality and arbitrariness is to ascertain whether a particular restriction on liberty was enacted in good faith, or was instead enacted to serve a purpose that is outside the legitimate police power of the states. Such illicit motives include, for example, the desire to benefit some persons or firms at the expense of others, or the desire to stigmatize the exercise of a liberty of which the legislature disapproves, or to make its exercise more costly because they don't like it. In other words, courts should be trying to smoke out pretextual legislation that only purports to serve a health and safety rationale, but is really enacted for other improper motives that are not within the just powers of a Republican legislature. In the words of John Marshall in McCulloch versus Maryland, when speaking of the power of Congress, not of the states, but of Congress, quote, should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects or purposes not entrusted to the government, it would become the painful duty of this tribunal, should a case requiring such a decision come before it, to say that such was not the law of the land. For this reason, we need not fear the imprecision of the Privileges or Immunities Clause. We don't have to be so afraid of it. We don't need a list of precisely defined rights that trump government power, because rights shouldn't trump government power that way. What we need is a conception of the proper ends of federal and state power, and a realistic evidence-based assessment of whether a restriction on any liberty is rational or irrational with respect to that purpose, or whether it arbitrarily treats some differently than others. And this is just the sort of inquiry we can expect courts to employ when assessing restrictions on speech or the right to keep and bear arms. Unfortunately, in the latter case, they've been reluctant to do that, but that's what they ought to be doing with respect to the right to keep and bear arms. So should courts reconsider the Privileges or Immunities Clause? That's the topic of our debate today. If courts should be enforcing the original meaning of the Constitution, I say, as I believe they should be, I say then the answer to this question must be yes. Thanks.
Well, let me just respond, if I can, to Professor Barnett. There are, in fact, some aliens on some planets who I think are more favorably disposed to my position than he suggested. It's just earthlings among whom I'm not doing very well. But let's see if we can't have some impact on that today. It's an honor to be here. As a former House and Senate staff person many years ago, I first participated in heritage programs and worked with heritage people more than 40 years ago, and it's great to be back here again today. Let me preface my remarks by observing that whenever one speaks about the Privileges or Immunities Clause, he or she could always be mistaken. And this is particularly true when one's perspectives on the subject, as are mine, are contrary to those of Professor Barnett, who's written some wonderful pieces on this issue. I could be mistaken, and indeed I'm often reminded of that when I speak with my judicial colleagues on a weekly basis. Nonetheless, let me have a go at this. I do not favor revisiting the Privileges or Immunities Clause of the 14th Amendment or the Slaughterhouse decision. First of all, I do not join in what I recognize as the modern consensus here on earth that the Slaughterhouse case is a decision entirely lacking in redeeming value. I don't believe that. I do believe, however, that it erred in its central contention that the protections afforded by the Privileges or Immunities Clause were only those that pertain to federal citizenship. As a result, Slaughterhouse did leave a critical void in the application of the 14th Amendment. Its overly restricted interpretation is perhaps explained both by the fact that the court itself in 1873 suffered from the same confusion concerning the meaning of the clause that has persisted to this day on the part of those who seek to understand its meaning, and by the court's efforts to avoid what it may have viewed as diluting and dispersing the emancipatory purposes of the amendment to an entirely non-emancipatory context. There was, in short, almost certainly no lack of good faith toward the work of the 39th and 40th Republican Congresses by a court whose majority was comprised of 4 or 5 justices appointed by Presidents Lincoln and Grant. But the court's error was considerable, and it did transform and narrow the Privileges or Immunities Clause. And as a result, the purposes of the amendment to foster non-discrimination and equal treatment on the basis of race, color, or previous condition of servitude, and to overturn the black codes existing in many of the southern states did have to be achieved by an alternative means, and they were. But just as the majority justices were mistaken in significant respects, so too, I believe, were the dissenting justices, in perhaps even more egregious and potentially enduring manner. The positive legacy of Slaughterhouse is that in the wake of the Civil War and in the midst of Reconstruction, the country was spared from those dissents, each reading the clause far too broadly by exalting judicial power and federal power at the expense of state legislative power. Indeed, even the losing counsel in Slaughterhouse, John Campbell, recognized this and later remarked that it was, quote, probably for the best for the country that the case so turned out. And Supreme Court Justice William Moody, 30 years later, summarized the perspectives of many at the time. Had Slaughterhouse been decided differently, it is easy to see how far the authority and independence of the states would have been diminished by subjecting all their legislative and judicial acts to correction and review by the judicial and legislative branches of the national government. Flawed as it was in significant ways, what I believe Slaughterhouse got right was, first, its recognition that the pervading purpose of the 14th Amendment was the freedom of the slave race and the protection of the newly emancipated blacks from the oppression of those who had formerly exercised dominion over him. Second, its recognition that the 3 distinct protections of the 14th Amendment each needed to be read in the light of this dominant unity of purpose to redress the evils of African slavery, not to negotiate local economic disputes between bickering butchers. Third, its recognition of the distinctive role of state and federal citizenships and their equally distinctive privileges or immunities, and in its rejection of dubious judicial power-enhancing constitutional concepts of substantive due process, arbitrary equal protection categories applied to the exercise of local police powers, and the asserted equivalence under the Reconstruction Amendments between the former servitude of the black race and the supposed new servitude of those who were ensconced on the losing side of a local controversy as to how best to ameliorate the filth and foul air created by the butchering trade in New Orleans. Most importantly, though, what Slaughterhouse got right was its conclusion that the Louisiana law, enacted by a newly biracial state legislature, was none of the business of the federal judiciary under any of the provisions of the 14th Amendment, having nothing to do with the pervading purpose of the new constitutional amendment. To have decided this matter differently and to have introduced natural rights premises into the new amendment would have potentially constituted the court, in the words of Slaughterhouse, a perpetual censor upon all legislation of the states with authority to nullify such as it did not approve. At issue then in Slaughterhouse were a number of great issues: the nature of the judicial power, the continuing vitality of the great principles of federalism and the separation of powers, the debate in Calder versus Bull over the role of natural rights in the process of constitutional interpretation, and how best to protect individual liberties by judicial decision-making or by decision-making of the people in accord with the Constitution's great principles. In more modern parlance, I believe the debate reflected in that case was between justice and justice under law, and between the rule of law versus the rule of men. To both sides in Slaughterhouse, the old Constitution had been forever changed by the 14th Amendment, but to the majority, those changes were limited to redressing grievances that had clearly precipitated the recent hostilities. Except for the former slave, the Union is as the Union was. Except for the former slave, the Union is as the Union was. While to the dissenters, the changes were more far-reaching and fundamental. Second, what is meant by the Privileges or Immunities Clause, apart from the fact, at least in my judgment, that both federal and state privileges or immunities are protected against abridgment? To this, I have two answers. First, I don't know. I don't know because there are as many theories of the clause, as Paul indicated, as there are law review articles on the matter, because Judge Bork is probably right that the clause reads essentially as an ink blot in a Rorschach test, because even the dissenters in Slaughterhouse could not agree on its meaning, and over the course of their own judicial careers, each moved seamlessly between different theories as to why the Slaughterhouse majority had erred, and because other very thoughtful scholars who have looked carefully at the record have concluded variously that the clause is impossible to harmonize, confused, utterly uncertain, virtually boundless, a blank check, standardless, mysterious and cabalistic, vague and variegated, and murky. And these are only the views of those who have proceeded notwithstanding to suggest some theory of the clause. Never mind those who gave up well before that point. Quite likely, Senator Reverdy Johnson of Maryland, a former Attorney General of the United States, was the most insightful member of Congress when he opined during the debates on the clause, "I do not understand what will be its effect." Nonetheless, I too will briefly speculate as to its meaning. It's a wonderful parlor game in a busy cottage industry, to abuse my metaphors. But I do this tentatively because, as one distinguished professor of law has observed, to say that the clause is consistent with one's own theory of its meaning is uninteresting because the clause is consistent with almost everyone's theory. In short, I believe the clause prohibits state discrimination between blacks and whites as to a relatively broad array of positive rights of citizenship, rights that owe their existence to the states, the character of the states, their constitutions, and their laws. That is, just as the Privileges and Immunities Clause of Article 4 protects one class of citizens, those who are traveling or visiting another state, the Privileges or Immunities Clause of the 14th Amendment also protects one class of citizens, in particular African Americans, from discriminations within their own state. Article 4 is thus focused upon interstate discrimination and compares citizens who are travelers and visitors within a state and those who are residents, while the 14th Amendment is focused upon intrastate discrimination and compares residents within a state who are African American and those who are white. It is this principle of non-discrimination, I believe, that characterizes both clauses, not any minimum or substantive rights principles grounded in either natural law, the Bill of Rights, or any other body of positive law. That is, the privileges or immunities of state citizenship are those that are defined and established by the states. To the extent there is any incorporation occurring, it is the incorporation of state constitutional rights to visiting citizens and resident blacks, most of which rights, for example, in a state such as my own of Michigan, are largely indistinguishable from those in the federal Constitution. I reached this position for a number of reasons based on a number of textual and other clues that I'm probably going to have to pass over at this moment. But in particular, I would like to emphasize one aspect of that evidence, and that is the legislative history, but even more particularly, the negative legislative history. I'm influenced by my understanding of the clause by consideration of the surrounding legislative and historical circumstances, in particular that negative history, that is by the dogs that never barked during the extended debates on the clause. As remarked, for example, by one pioneering historian, Raoul Berger, in the wake of the Civil War and in the midst of Reconstruction, is it conceivable that Congress would have sought to exacerbate matters by a constitutional amendment radically altering the Constitution in ways having nothing to do with black rights and transforming not only the relationship of southern states to the central government, but also the relationship of prevailing northern states, were northern armies marching under their state banners in order to diminish their own state's sovereignty. And Professor Charles Fairman has similarly observed the freedom that the states traditionally have exercised to develop their own system for administering justice repels any thought that the federal provisions on grand jury, criminal jury, and civil jury would be fastened upon them in 1868 by incorporation. Congress would not have attempted such a thing, the country would not have stood for such a thing, the legislatures would not have ratified such a thing. The electoral campaign of 1868 was fought over the proposed amendment, but the debates never took the turn of suggesting that ratification would involve major changes in the administration of justice in the northern states. And it is further unlikely, I believe, that a northern public inflamed only a few years earlier by the Dred Scott decision, denying forever black persons United States citizenship and discovering a constitutional right to introduce slavery into the territories through the magic of substantive due process, would ever have consented to allow exercises of judicial decision-making and discretion to persist in the future in the name of the pursuit of happiness, the common sentiments of the people, silent and unenumerated rights, natural and inalienable rights, or even the great Adam Smith's wealth of nations. As remarked by Justice Iredell near the time of the birth of the Republic in Calder, the ideas of natural justice are regulated by no fixed standard. The ablest and purest men have differed upon the subject, and all that a court could properly say in any such event would be that the legislature, possessed of an equal right of opinion, had passed an act which, in the opinion of the judges, was inconsistent with the abstract principles of natural justice. Third and finally, I would not revisit the Privileges or Immunities Clause for the reasons implicit in my remarks thus far. There is no shortage as to what the clause means, but there is also little consensus or agreement as to what it means, a conclusion reached even by Justice Thomas, who is the only revisiting current justice. It is one thing for all of us to have engaged in the many academic exercises of the past 150 years in attempting to discern what the clause means, and yet another to establish a new supreme law of our land when this has not yet been made clear. While I do very avidly share many of Professor Barnett's premises concerning the elements of a free society, one premise with which I respectfully disagree is that our constitutional path towards such a society can be built upon the foundations of a stronger judiciary, in particular one that, in my judgment, will no longer be exercising the traditional Marbury versus Madison judicial power, saying what the law is, but instead increasingly exercise a transformed and 21st century constitutionalism notion of judicial power, saying what the law ought to be. Professor David Curry was right, in my opinion, in his characterization of contemporary efforts to broaden the clause, as well as such other provisions and concepts, such as the Ninth Amendment, substantive due process, a contextualist equal protection clause, the general welfare clause, the right to privacy, and the commerce clause, in which Professor Barnett has done such a wonderful job. These are essentially a quest, I believe, in agreement with Professor Curry, for the constitutional Holy Grail, a supreme law empowering our judiciary to do essentially anything that it desires. And make no mistake about it, when that Holy Grail is finally discovered, when it's finally achieved, it is quite unlikely to reflect anything along the lines of what many of you may envision. That is, to say the least, is where our legal and academic cultures are not today. Other scholars looking to this exact same language in the 14th Amendment, the exact same history, and the exact same surrounding circumstances as each of you, and who have the exact same interest in revisiting and revitalizing it as some of you may have, they have discerned in the clause some of the following things. They have observed some of the following things in terms of supplementing and embellishing what the current Constitution is focused on. For example, some scholars have argued that a revitalized Privileges or Immunities Clause would establish new positive rights to public benefits and entitlements. Others have said it will strengthen minimum welfare standards and welfare state rights. Others have focused upon obligations of equal treatment, educational equality, redistributive mutual aid policies, overcoming the limitations of the state action requirement, common law rights, sexual rights, health care rights, distinctly personal rights, the ability to respond to economic disparity rights, union rights, equal standing in the national political community, equal citizenship, redressing violations of customary international law, opportunities to make the most of our lives, unenumerated rights, privacy rights, rights of felons, fundamental rights contained in the Northwest Ordinance, private law rights, all of the rights in the Bill of Rights, including those that have not yet been incorporated, deeply rooted rights, environmental rights, entitlement to a college education, rights associated with the polity, human rights, rights stemming from our obligations to our community, rights drawn from our affirmative entitlements, to name a few. And by the way, rest assured that the tricky word citizens in the Privileges or Immunities Clause will never, we are told by these same scholars, I don't mean to point here, but that's not my intention at all, but rest assured that the tricky word citizens will never, we are told by those scholars, serve as a barrier to protecting the interests of legal and illegal aliens, but only those of corporations. And as the estimable Professor Jack Balkin opines, finally, after all of this change, there will be nothing left of the founders to fetishize, indeed. For these commentators, the clause's strength is its very vagueness and inclarity. its useful service as a truly new and fresh constitutional tabula rasa, suffering from none of the restrictions and imperfections of the old Constitution, its 18th century emphasis upon so-called negative rights, and the formalistic need to take into account the difference between that which is private and that which is public. Of course, I would not favor a revisiting of the clause, even if I was quite certain that Professor Barnett's favored rights would prevail, much as I would be tempted. I believe the ultimate guarantor of our freedoms lies within the great principles of our Constitution, principles that in so many respects have been eroded and diluted over the decades by the very lawyers in black robes whom proponents of a natural rights constitution would place so much faith in giving greater meaning to the Privileges or Immunities Clause. The least harmful branch, however, is no longer that, and in my view, it would be better first to restore the integrity of our traditional constitutional architecture by revisiting the decisions that have already been so transformed by the courts, our founding institutions. But unlike Slaughterhouse, we are told that all of those decisions, the decisions creating 4 branches of government and eroding federalism and undermining the separation of powers, we're told that all those decisions are settled, are long settled. The only one that's not long settled is the Slaughterhouse case, which has stood up for tradition, imperfectly, but it has stood up for the values of federalism, one of the great principles protecting and honoring our freedoms over the 200 years of our nation. The burden of proof for great constitutional change, and that's what this is upon the proponents of that change, I respectfully believe, and in my view, they are nowhere even close to having met that burden. As Justice Scalia has said, by trying to make the Constitution do everything that needs to be done from age to age, we shall have caused it to do nothing at all. Thank you.
Thank you, Judge Markman. I'm supposed to only have 5 minutes to respond, and I'm just not going to be able to get into this entire parade of horribles that you heard. I mean, it made me shiver. I mean, if I didn't know we were going into a momentous election, I'd have something to be upset about, but we have other things to be upset about. Let me suggest I'll just make one response to that, and I want to return to the topic of what the Privileges or Immunities Clause might mean, and that is that the left of whom you speak, the academics, my colleagues of whom you speak, they don't need the original meaning of the Privileges or Immunities Clause to do all the things you say. What do they need? They need one more justice. They need one more justice to do everything you say. And they can do everything you say with the Due Process Clause they've already got. They can do everything you say with any other clause that they want to pervert into whatever it is they want to make it mean. So you can't inoculate ourselves from all of the consequences of having 5 justices prepared to say that all those rights are rights by somehow running and hiding in our head about what the original meaning of the Privileges and Immunities Clause was. So I think it's short-sighted to think you're going to stop them from doing what they want to do by denying what the clause meant, if in fact the clause meant something else than what you say. So I would just sort of put that to one side, go back to what the clause might mean. Justice Markman says that the clause needs to be read in light of its dominant purpose, which is about race and not butchers. Well, let me just suggest that that's not how it was written. The people who wrote the 14th Amendment were perfectly capable of writing a civil rights law that addressed the problem of race. You know how I know that? Because they did. They did it many times. There's a Civil Rights Act of 1866, of 1870, of 1875. Over and over again, they passed laws that were put in terms of race. This one wasn't put in terms of race. It was put in terms of the privileges or immunities of citizens of the United States, all citizens of the United States. And in that sense, the majority in Slaughterhouse actually affirmed that as well, I should say. Even the majority in Slaughterhouse understood that was true. So I don't think that we should read into the clause a limitation that isn't in the clause. I mean, that seems to me like if judicial activism means anything, that would seem to be judicial activism to me. I think we should stick with the wording that it had. Now, you'll remember I read you what Jacob Howard said the clause meant. And it turns out what Jacob Howard said the clause meant was what Charles Fairman said that no one at the time of the 14th Amendment could ever have even imagined it meant. Well, who are you going to believe? Charles Fairman or Jacob Howard, who was the Senate sponsor of the amendment, who said it did relate to jury trials, it did relate to all of these things, and whose words were published in the New York Times and across the United States in newspapers verbatim. You going to believe Charles Fairman, or are you going to believe Jacob Howard? Now, there is a portion of Jacob Howard's speech that did address the problem of race that I omitted from my comments because I was trying to confine myself to the meaning of the Privileges or Immunities Clause, which is the subject of this debate. There is a paragraph I left out. I can't read it to you because I didn't bring it with me. And that's where he talks about the problem of race. And in that paragraph, he's talking about the Due Process Clause and the Equal Protection Clause. Now, I don't know if that's the only part of the 14th Amendment that deals with that problem, but when he was dealing with that problem in his speech, that's what he was talking about. When he was talking about the Privileges or Immunities Clause, none of that constraining purpose that Justice Markman just told you about was mentioned. I read you the whole thing, and it didn't say anything about race. Now, what is the consequence of having adopted the majority's approach? Justice Markman cites John Campbell as having thought that it was best for the country that the case turned out that way. John Campbell was the lawyer who argued on behalf of the butchers in the Supreme Court. He's the one that argued. He lost the case 5-4. He's the one that argued that the Privilege and Immunities Clause did protect the right of butchers. But who was John Campbell? Who was John Campbell? John Campbell was a former Associate Justice of the Supreme Court appointed to the court by President Buchanan. He resigned from the court in order to return to his native Alabama and fight for the Confederacy, where he was named Secretary of War, a position he held throughout the entire Civil War. And then he resumed his practice of law. In fact, if Andrew Johnson had not issued his hugely blanket pardons to everyone in the South, John Campbell would not have been eligible to practice law and argue in the Supreme Court of the United States. But thanks to President Johnson, he was able to. And he represented the butchers as a means of undercutting what the justice correctly told you was a biracial Republican legislature that had been elected under a new and liberal constitution that was Republican in nature. And he was attempting to use the Republicans' law against Reconstruction in the South. But he lost. And the person who won was a lawyer named Jeremiah Black. And Jeremiah Black was somebody who was a Democrat. I won't go through the whole history of who Jeremiah Black was, but he was the lawyer who was trying to undercut Reconstruction by gutting the 14th Amendment. And he was a Democrat. He was the Attorney General under Buchanan. Buchanan had meant to name him to be the successor of Roger Taney, but when Roger Taney hung on, he didn't get named to the Supreme Court to be Chief Justice. He's the one that brought ex-party militant Milligan in the courts, and he was trying to gut Reconstruction by gutting the 14th Amendment, and he succeeded. And it was the success that Jeremiah Black had in gutting the 14th Amendment that John Campbell was later praising as the losing person in that suit, is saying, you know, on balance, it was probably better off for the country that I lost that case. Because, in fact, gutting the 14th Amendment turned out to be a bigger defeat for the Republicans than anything that and I'm adding this, that's not what he said. He stopped. It would be better off for the country. Now, I go on to say, because gutting the 14th Amendment turned out to be a bigger victory against the Republicans than what I was trying to do. Okay. So, if the dominant purpose wasn't race, what is the negative consequence of gutting of the Privilege and Immunity Clause? Well, I submit that the negative consequence was felt on the day after Slaughterhouse was decided, after his decision was announced. The day after Slaughterhouse's decision was announced, the case of Bradwell versus Illinois was announced. And in Bradwell, Justice Miller, the same justice that wrote the Slaughterhouse decision, said, and Bradwell versus Miller concerned the right of women to practice law in Illinois, a right that had been denied to a woman named Ira Bradwell who had passed the bar in Illinois. And actually, she was actually a pretty distinguished legal commentator, the editor of the Illinois Law Bulletin. So anyway, she was denied the right to practice law, and Justice Miller, the day after Slaughterhouse, said, well, if we were right about anything that we said yesterday in Slaughterhouse, this case is easy. And that is that women, there's no right that's being asserted here that's protected by the U.S. Constitution. In this case, she was asserting her right to pursue a lawful occupation, free of an irrational or arbitrary restriction. And so Myra Bradwell loses. So the immediate consequence of Slaughterhouse was felt the next day. When a woman, not somebody who was a racial minority, but a woman was denied the right to practice law. And then that subsequently led, in very short order, to another abdication by the court, which was Plessy versus Ferguson, because Plessy versus Ferguson was a case following Slaughterhouse, citing Slaughterhouse, in which the court says, it's up to the state of Louisiana to decide what public order is required. They say public order is required here. End of story. It was a one-sentence consideration of whether the right to keep blacks, to segregate the trolley cars in New Orleans between whites and blacks was rational or arbitrary. One-sentence decision said, following Slaughterhouse, that's really up to the states to decide. So even race didn't turn out to be so good under the Slaughterhouse opinion. So I guess I would say, let's go back to the original meaning of the Constitution. Let's go back to the original meaning of the Privileged Immunities Clause. But this does not mean, to reiterate what I said in my talk, this does not mean identifying a whole set of rights and enforcing those rights the way we are accustomed to thinking of enforcing rights as a means of trumping all legislative power that might be inconsistent with that. Liberty rights may be reasonably regulated, but they must be regulated in good faith. And the reason why courts have historically used the criteria of irrationality or arbitrariness is to ascertain whether, in the words of John Marshall, these are laws that are meant to serve a purpose or object that are within the government's power to do, or in fact are pretexts for other motives, for other purposes that are not within the government's power to do. That's all that protecting these rights would require. And it's something that courts do every day, and it's something they ought to do every day. And I want to agree at the end of the day that I think there's a very good chance, in fact, I think there's an excellent chance that the Slaughterhouse Act would have been upheld as a reasonable regulation of the health and safety of New Orleans under the record that had been developed by the legislature below. So the ironic thing here is that the case was probably rightly decided on the facts. It just gutted the constitution of a right that has proven that the loss of which has proven to be very dear.
I can see from looking out in the audience, there are a bunch of people here who have questions. So I'll forego any questions I may have to allow you to ask questions of our two distinguished speakers and to allow them some back and forth as well in response to questions. Let me just ask first that you identify yourself, your name and the institution you represent, and then ask a question. And if you can, please keep it brief. Yes. We have a microphone coming, if you give us just 5 to 10 seconds.
And this is Ken Misuki who's about to talk.
Hi, thanks for the introduction. I'm with the Claremont.
I'm not going to introduce everybody in the audience, but I will introduce you, Ken.
Okay, you can anticipate my question then, which the context of privileges and immunities and the 14th Amendment is, of course, the 13th Amendment. And I think we may go off in thinking of the 13th Amendment as primarily or exclusively an attempt to protect blacks. But it's also, by abolishing slavery, a prohibition on the tyrannical behavior of masters. And I think that it's as much that Lincoln had in mind in getting the 13th Amendment through. And I think when the 13th Amendment also modifies the whole Constitution, meaning the Republican Guarantee Clause as well. So I think all of this goes to goes to show that privileges and immunities may not mean simply protection for blacks, but restrictions on tyrannical behavior of citizens.
Well, I'm not sure I completely agree with that. The 13th Amendment seems to be one of the most straightforward and clear amendments that we have in the Constitution. Neither slavery nor involuntary servitude shall exist within the United States. I understand that the Supreme Court has expanded that by allowing statutes focused upon the so-called badges or incidents of slavery to somehow fall within the scope of that amendment. But I guess I'm concerned that you may be generalizing, and you probably know more about the amendment than I do, but I think you may be overgeneralizing as to the focus of the amendment. I'm not really sure what the consequences would be of dealing with the amendment as one focused upon masters as well as the slaves, but I do think that at least our default principle ought to be that the most obvious and reasonable and straightforward meaning of a constitutional provision is the one that ought to, and I think Professor Burnett would agree with that too, but I'm not quite sure where we're going in terms of the overgeneralization that I think you're engaging in here.
I guess one thing I would add, I did allude to this in my original remarks, and that is that the Civil Rights Act of 1866, which regulated the treatment of the freedmen, who were no longer technically slaves anymore, and it protected their rights to make and enforce contracts, to sue and be sued, to hold and possess and own real and personal property. These were all right. This was a statute passed by Congress under its 13th Amendment, Section 2 authority. Andrew Johnson vetoed it on the grounds that it was unconstitutional because it went beyond the literal abolition of slavery, and a supermajority of Congress overrode him. Having said that, there were some Republicans who were somewhat concerned that Johnson might be right. And that's one of the several, not the only, but one of several motivations that led to the 14th Amendment. But nevertheless, it was sufficiently powerful that they could do this because what was the South doing? The South was trying to reimpose slavery without calling it slavery, using the black codes and other things. This is what they were trying to do, and they kept trying to do it for another 100 years. And Republicans thought that they had the power under Section 2 of the 13th Amendment to stop that from happening, even if it was happening incrementally and it was not happening all at once.
Stuart.
Stuart Gerson, Epstein, Becker, and Green. Professor Barnett, if indeed your critique of Judge Markman's parade of horribles is correct, that those things could be reached with a different majority, perhaps the same thing could be said of the two criteria that you state for the rejuvenation of the clause. And if indeed that's so, that this court, even with the people on it, could deal with legislation that is irrational and arbitrary and also discriminatory of one class against another, what sort of case would you envision would create a necessity to revisit the clause?
I mean, I think at this point it's really useful to just go back to a more prior principle that I'm sure that Justice Markman and I agree with, and I'm sure you, Stuart, also agree, and that is to ask, how should a written constitution be interpreted? What is the purpose of a written constitution? And then how should it be interpreted? So let me just briefly say, the purpose of a written constitution is to provide the law that governs those who govern us. A written constitution provides the law that governs those who govern us. And that means those who govern us should not be able to change the law that governs them without going through the amendment process, any more than we can change the speed limits that are imposed on us without going through the legislative process. And so that means that the meaning of the Constitution should remain the same until it's properly changed by Article 5 Amendment. It says how it's properly changed. So there is a virtue in following the Constitution as a law that governs those who govern us, the whole Constitution, even the parts that some people think are inkblots. The inkblot answer, by the way, was not a really good answer for an originalist to provide for what the Constitution means. Well, you know, that provision, that's an inkblot. Actually, the inkblot, you know, originated on the 9th Amendment, and by the time The Tempting of America was published, it moved over to the 14th Amendment. And the 9th Amendment had a meaning because he found Russell Kaplan's article, and that gave him a meaning for that. So at any rate, I would say that the virtue is to get the Constitution right. Let's start with the Constitution. Don't start with the consequences. Start with the Constitution, and then take the Constitution, the consequences that the Constitution leads to. We'll deal with them at that point, rather than go the other way around. In fact, in a way, I'm sure he didn't mean it this way, but that was a very result-oriented analysis of the Constitution, wasn't it, at the end, that parade of horribles? Look at all the results, the bad results that none of you are going to like, that will come about as a result of interpreting the Constitution the way you say. Therefore, don't interpret the Constitution the way you say. That sounds like result, or I know that you don't practice your judging that way, but at least in a lecture here, it was a very result-oriented approach, and I would say, first things first. Was the Constitution mean and stay true to it? It may lead to some results we like, it may lead to some results we don't. But I think on balance, I like our Constitution. The progressives didn't like the Constitution. They thought it was a horse and buggy Constitution. They wanted to get rid of it, and they invented the living Constitution. I like the Constitution we have. If you don't like it, change it, or at least admit you don't like it. But let's stick with the Constitution we have, and then let the results fall where they may, and amend the Constitution where we don't like the results.
Yes, sir.
Hi, Jeff Long. Jeff Long here from clerk for Judge Silberman on the D.C. Circuit, though not representing him, just given leave from his chambers. Wanted to thank you for the discussion. I graduated just this past May, and I think it illustrates so perfectly the discussion taking place in the Federalist Society and on campus between moderate, libertarian, conservative students regarding this frustration between those who came up at a time that stressed judicial restraint for obvious reasons that you heard in Judge Markman's remarks, and at the same time, this frustration on the part of younger students who felt very much like students of our persuasion, and attorneys and ultimately judges and justices and professors were fighting with one arm tied behind their back because while attempting to respect a restrained judiciary, even the restraints that had been imposed were completely disregarded by those who sought to see in the Constitution whatever they had hoped for. I guess my question would be for Professor Barnett, how a reinvigorated Privileges and Immunities Clause would differ necessarily from a Lochner-era type approach to substantive due process, one which recognized a certain right to contract and a liberty to property combined with others, which may result in kind of an approach which at least clears out more space for individual liberty than we see now under a privacy-based substantive due process. And then alternatively, and sorry if I'm taking up too much time, how even the framework you had proposed under the Privileges and Immunities Clause would differ from the kind of weak, completely ineffectual rational basis review that we see now. And if that were the case, if that's how it were taken, what difference it would really make. Thank you.
Well, this has been a big week for me. So on Wednesday night, I told you I gave the Supreme Court Historical Society lecture on the Slaughterhouse case. On Monday night, I did a 90-minute C-SPAN landmark cases show on Lochner. So this is all somewhat fresh in my mind. Let me suggest that Lochner has been greatly distorted initially by progressives like Teddy Roosevelt, who made it a campaign issue in 1912. Prior to that, the Bake Shop Act was not much of a big deal, but then he made it a big deal. It was like demonizing a particular case for political ends. I was just thinking after my court, it was like the Citizens United of a day, right? They took this and they made it a campaign issue, like they're taking Citizens United. They took Lochner and did this to that. But in fact, what's anachronistic about our reading of Lochner is that, and so we're reading it in this post-New Deal, post-progressive eyes, is we're saying they elevated the right of contract above everything, and then that's why they struck this down. And that's just not the way the court worked back then. It's not the way they worked in Lochner. In Lochner, there was a health and safety law that had 16 different provisions, very, very detailed regulations of health and safety. They only invalidated Section 110, one particular provision of it, because they found no legitimate health and safety reason for it. They are essentially looking for they use the traditional approach of whether a law is arbitrary or irrational. And they found that it was arbitrary in some respects because it treated bakers differently than it treated other people who had similarly dangerous occupations, and there was no real reason for the distinction. So therefore, they suspected, in the words of the court, other motives might have been responsible for its passage. Had that law, that particular section, been as supportable as a health and safety regulation as the rest of the Bake Shop Act was, the Bake Shop Act is reproduced by the court as an appendix to its opinion, and all the sections that they say are perfectly okay are right there in the Lochner case. Just like the Slaughterhouse Act was most likely a reasonable health and safety law. Again, because it would have satisfied this degree of scrutiny. So Lochner is very similar, and what is then the relationship maybe between the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause? I mean, this is obviously another topic we could have another panel on, but you might think of it this way. The Privileges or Immunities Clause essentially just stakes out or refers to what are the rights of citizens of the United States. And presumably these rights are enforceable. Remember what Senator Howard said is that, Congress couldn't enforce them without Section 5, so they're basically enforceable themselves. Then the Due Process Clause basically assures that when laws of a state are applied to particular people, that they will be applied accurately, they'll be applied fairly, and that judges will be, as part of the process of applying law, judges will be able to inquire as to really whether this was a law. And it's a law if it's general, it's a law if it's not arbitrary. An arbitrary act and an irrational act is not properly a law. So it's the due process of law that that judges may look into. And so the Due Process Clause is really quite closely related to the Privileges or Immunities Clause. And the Equal Protection Clause, in my view, is primarily about protection. It's about making sure that if you're enforcing the law for these folks over here, you're enforcing it for those folks over there. It's really about the enforcement or providing the executive branch protection of the law to everyone equally. But the laws themselves have to pass muster under both the Privileges or Immunities, under the Privilege or Immunities Clause and the Due Process Clause as well.
Well, can I say one thing very briefly? Professor Barnett said a little while ago, who are you going to believe, Senator Howard or Charles Fairman, I think it was. Well, let me tell you one thing about Senator Howard, and I agree with Professor Barnett. If you're going to find one individual who favored a very broad application of privileges or immunities, and particularly the incorporation, there was really not much of a natural rights flavor to his analysis. But to the extent you're going to find one member of Congress who stood pretty clearly for the idea of incorporation, it was probably Jacob Howard. And you need to know that about 5 years before this, 5 years before the 14th Amendment became part of the Constitution, Fairman tells the story of how Senator Howard, as Attorney General of the state of my great state of Michigan at that time, was the sponsor of a proposal that reaffirmed Michigan's traditional policy of allowing criminal trials to proceed on informations, not indictments, which of course would be unconstitutional if the Fifth Amendment to the Constitution were in fact incorporated against the states. Notwithstanding his statement about the incorporation of the entire Bill of Rights, when the 14th Amendment became the law of the land, Senator Howard never said one single word about what he had imposed upon Michigan in terms of the allowance of criminal trials absent indictments. He never criticized it. He never suggested it be changed. It wasn't changed. Nobody ever raised the idea that it be changed. So whatever Senator Howard was really trying to communicate by indicating that the privileges or immunities language was designed to forever incorporate the Bill of Rights, he really didn't walk the walk when he had an opportunity. And at the same time, and typical of many members of the Congress, Senator Howard said several days earlier, before he made that statement, as to the purpose of the proposed amendment, there is to be hereafter no distinction between the white race and the black race. It is to secure to these men whom we have made free the ordinary rights of a freeman and nothing more. Listening to that, would you think the purpose of the amendment was an equality, a non-discrimination purpose, or would you think it was, in fact, to incorporate all of the substantive protections of the Federal Bill of Rights?
Let me recommend to you two recent books, neither one of which do I agree with 100%, but they're good and they're recent. One is by Kurt Lash on the original meaning of the Privileges or Immunities Clause, and another is by Christopher Green. Also, I don't remember the exact title of the book on the original meaning of the Privileges or Immunities Clause. They both came out last year. They're both very, very good. And one of the things that you will see from particularly the evidence that Kurt produces is that there's a lot of people, when asked both in Congress and in the press, because by the way, he's examined a lot more press reports than we previously had access to. There's a lot of people who say, well, you know what this is about? This is really about the rights that are enumerated in the Bill of Rights, or the rights that are in the text of the Constitution. There's statement after statement about that. And then there's a whole bunch of other people who say, you know what this is really about? It's really about equality. You got a whole bunch of people saying this is really about equality, and a whole other bunch of people saying it's about the rights that are in the text of the Constitution. This suggests that the language is susceptible of including both, What you don't find, in fact, I don't remember finding in Kurt's book, and I was just with him, and I should have asked him if I've misread his book. Maybe I've overlooked this, but I don't find anybody who believed who was advancing the textual rights argument saying it is not about equality, or anybody who was advocating the equality reading was saying it's not about textual rights. That is, you don't really have people who were denying that it's about textual rights, and you don't have people who were denying it was about equality. I think the most plausible reading of the evidence, I mean, a very long and complicated record, is that this wording had a public meaning, and this public meaning both effectuated textually supported rights and the equal treatment of people underneath it. And you also have to remember that when Jacob Howard was making that earlier statement, he was talking about the 14th Amendment as a whole, and I told you I left out the paragraph of his later statement in which he talked about racial equality, in which he was talking about the Due Process Clause and Equal Protection Clause. So we can only, this discussion of purposes can only take us so far. And this is one of the reasons why originalists were criticized for focusing as much as they were on the original intentions of the framers, because there's so many intentions of framers. You can just come up with so much that it ends up making everything indeterminate. And originalists, starting with Justice Scalia in the 1980s, began to realize that what really mattered was the original public meaning of the text itself. And that's what I was saying Jacob Howard was explaining. What does the text mean? He wasn't stating all the purposes why we would do it, only what do those words mean. And again, it's only one statement, but it happens to be one by the sponsor of the bill in the Senate, and it was broadcast throughout the country in newspapers, and the amendment started to become called the Howard Amendment as a result of that speech.
I do think Professor Barnett makes a very, very good point as to the nature of the debate. It was a very confused debate. There were a great many ambiguities. I mean, there are all kinds of ambiguities about, where individuals were focusing upon the privileges and immunities provision or the privileges or immunities provision, where they were talking about state citizenship rights or federal citizenship rights. And he's absolutely correct on that. That really characterized the debate. But let me say there was also a confusion when members talked about things like natural rights or the Declaration of Independence or fundamental liberties and fundamental rights, because it was the view of most of those individuals, I think, that these were the kinds of impulses that underlie the positive law of the state. It wasn't that it was an either or, but they looked upon their positive laws, they looked upon the law of the land, and they said, this is where those rights have come from. They've come from God. They've come from something greater than the people. Not that there was a tension between the two, but that was the source of the positive laws that we had in the United States and among the states.
There was a canonical statement of natural rights. It was written by George Mason. It got put into the constitutions of 5 states. It was used to invalidate slavery in Massachusetts. Justice Washington cites it in Corfield versus Coryell, and people in Congress cite that. It's not that difficult. There wasn't that much disagreement about it, but those rights are very abstract. They do not decide particular cases. They are not an argument for deciding particular cases particular ways. I suggested to you the way those get implemented is by asking whether a state legislator or Congress is exercising one of its just powers in good faith. If it is, it's constitutional. It's not inconsistent with those rights. If it is not, it may violate those rights. But you don't just go to the natural rights and then figure out what they are and then enforce them the way you would enforce, like the way we today enforce the natural right of freedom of speech. That's how we do it. It's not how it was always done, and it's not how it needs to be done.
And just so you, one more thing, just so you have the full context in Corfield versus Coryell, which was indeed a very significant case in the early years of the Republic, there is language there after the individual rights are laid out that says, subject nevertheless to such restraints as the government may justly prescribe for the general good of the whole.
I read that.
No, I wasn't suggesting.
I did, up there. I read that. Yeah.
What that language does is to transform what might be sufficiently ambiguous to suggest a natural rights definition of the term privileges or immunities into a very conventional positive right interpretation. And also, let me respond to my friend Randy when he talks about John Campbell, who may not have had a crystalline clear reputation in some other respects, that Bushrod Washington, who wrote Corfield versus Coryell, happened to be not only a slave owner at the time, but it was suggested by many commentators that he put the concept of suffrage in there as a privilege or immunity, precisely to make sure that it was more difficult for blacks in State A to have all the comedy rights under Article 4 when they moved to the other state. So we don't necessarily have saints here, but Randy's correct, and we're not looking at what was in their mind, what was in their heart, but we're trying to look at objective circumstances as best as we can. But Bushrod Washington was no saint either, if we want to,
I enjoy disparaging the reputation of hallowed Americans as much as anyone. And I have to say that we've done a good job. And I also have to say that as mightily as the Reconstruction Congress worked to eliminate slavery, they failed because we all, in fact, are slaves to time. I think what we have is enough to allow you to go off and say the issue is still a live one. The issue is still an important one. And there are different views that have to be considered in order to decide what the right answer is. What I would like to do now is offer my thanks to two very distinguished speakers for giving us their time and their thoughts on these issues. And I hope you will join me in thanking them for what they have given us today.